Hello, good morning to everyone. I would like to thank you all to be here to attend this webinar. We have here also, I would like to thank Michele and Marina for their time to speak with us about monitoring cases before national and international authorities. So Daniel is going to present them, and let's start.
Thanks, Cecilia. Well, hi, everyone. First of all, thank you, Michele and Marina, for joining us. It's a great pleasure to have you here. Michele is a partner with StoneTurn. She has more than 25 years of combined experience in fraud and compliance risk management, compliance and monitoring, and auditing. She specializes in assessing, implementing, and remediating anti-fraud and compliance programs. I think she has a very good experience in monitorships, and it's going to be really, really nice hearing about your experience and sharing your thoughts with us. Thanks a lot for being with us, Michele. We also have Marina Copola. She's a partner at Yazbek Advogados. It's an amazing CV. Member of the Committee for Market Supervision and Monitoring of the BBCE. She was an associate at Debevoise and Plimpton's Capital Market Department in New York from 2012 to 2015. She was a technical advisor to Director Otávio Yazbek at CVM, international intern at the U.S. Securities and Exchange Commission, the SEC, in DC. She holds an LLM from Columbia University, an LLM in Economic Law, and BA from the University of São Paulo Law School. Thanks a lot for being with us as well, Marina. So our idea today is to discuss monitorships. This is a topic that, while we have some literature, we don't have a lot of, really knowledge and structured knowledge about how things work in practice. So it's great to rely on the expertise of professionals such as you to share with us your experience. We have some questions that we will go through with both speakers, but I would also like to thank a lot our audience. And please don't let me have the entire questions here. Please feel free to ask questions to the participants. We'll make sure that they get them. I think this is a great opportunity to, ask questions for those that really worked in practice in monitorships. And if we don't have sufficient time for them to answer your questions, we'll make sure that they will get your questions afterwards so that you can connect and you can have your answers as well. Maybe going right to it, starting with Marina. Marina, can you describe your background, your experience and expertise in the area of monitorships, the cases you've been dealing with, and what are your initial thoughts on monitorships?
Good morning. Can you hear me? All right. Well, good morning. I would like, first of all, to say thank you to Maria Cecilia and Danielle for the invitation. Hi, Dora. Thanks for the support. I also would like to say hello to Michele. We had a conversation last week. It was wonderful meeting you all. Well, Danielle, I became acquainted with monitorships in the compliance world. I wouldn't say accidentally, but serendipitously. As you noticed, my background is as a corporate and capital markets lawyer. And as such, during my time at CVM and afterwards at Debevoise and here at the firm, which was founded in 2015 when I came back from the US, we've always had, and when I say we, I mean to include Otávio, my now partner, who was the commissioner at the Brazilian SEC at the time. We've always had an interest and a focus on issues related to governance, internal controls, and the discharge of fiduciary duties by board members. Sorry, I'm just going to close this because it's pinging. Okay, sorry. I'm back now. The discharge of fiduciary duties by board members and managers of companies, and this goes way back to 2010 when CVM decided on the case of Sadia. The case of Sadia was a case that was brought by CVM, and that had a lot to do with how companies organized their internal controls in a broader sense. It came as a result of the subprime crisis of 2008. Sadia at the time nearly went bankrupt because of the management of its derivatives policy. And that was really the first time when CVM looked at the duty of care as a broader duty that included not only the analysis of red flags, but also the creation of an environment of control. At that time, Otávio was a commissioner. I was his technical assistant, and we started looking at this issue of controls in a manner that was, we think, very different from what was being discussed at the time. And we became sort of very excited about this I would say, junction between the corporate side and the compliance side. So after that, in 2017, after having spent a good few years assisting companies and boards and managers in this sense and how to best discharge their fiduciary duties, in 2017, Otávio was appointed the independent monitor for Odebrecht and counsel to the U.S. monitor also that was appointed by DOJ for Odebrecht. And that was really a really pivotal moment for us, because alongside the Braskem monitorship, this was really the first monitorship that was in place in Brazil. So there was a lot that had to be learned and built together with the MPF. There was really no blueprint in Brazil other than the experience of what's being done abroad, particularly in the US, and Michele is really the best person to talk about it. So we became more acquainted with this reality, and again, with the support of a wonderful team of people that are specialized in investigations, the compliance side of the monitorship. We had this wonderful, I would say, laboratory for how monitorships can function in Brazil. And I cannot stress it enough, because the expertise of people like Cecilia and Michele and you was really key for what we believe was the success of this monitorship in Brazil. So that's how it became. So it's a long story. It kind of goes back to the dinosaurs of our interest in this subject, but this is really how we became acquainted with it. And after that, we now work assisting companies in their process of monitorships, even not in the position of monitor, but how companies can organize themselves to better meet the requirements of monitors, or something that we can talk a little bit later, how to prepare themselves not to need a full-on monitorship if the authorities so require. So that's, I would say, in a nutshell, not really a nutshell, the nucleus of our experience.
No, it is very interesting, going through the duty of care, working at the CVM, and then how this would apply to monitorships. That's a very interesting perspective. And it's interesting how you got there to the monitorships. Michele, maybe if you could share your experience, your background as well with us.
Absolutely. And thank you, everybody, for joining us today. And thank you, Daniel and Marina and Maria, Cecilia and Dora, for this opportunity to join all of you and work with all of you. It's a pleasure and an honor. So I have a little bit of a different background than Marina, which is a great contrast, I think, which will be really interesting throughout today's discussion. I think that you'll find that no matter if we're speaking from a legal perspective or more from an accounting or forensic accounting perspective, we share similar views and we have similar advice of what's worked well given our experiences. And so it's, I think, going to be a really great conversation today. So from my perspective, I started my career as a certified public accountant working for PricewaterhouseCoopers as a financial statement auditor. And so I spent about 8 years conducting financial statement audits. And right around the time of all the massive fraud scandals that were happening in the US, you probably heard Enron, WorldCom, is when I really transitioned into a specialty group at PricewaterhouseCoopers that was focused on helping our financial statement auditors assess and respond to the risk of fraud as part of the financial statement audit, right around that time of the peak of the public accounting firm scrutiny related to these massive financial fraud scandals that were going on in the United States at the time. And so as part of that role in advising our own audit teams, I naturally began working with clients on how to build effective anti-fraud programs and controls and compliance programs and controls, as that was really a key part of that control environment that companies needed to ramp up given the new regulations related to Sarbanes-Oxley. And so that's really where I kind of pivoted my career into really helping advise companies on creating effective programs and controls to prevent and detect fraud and misconduct and compliance issues. Since I joined StoneTurn, I've been here about 8 years, and I've really specialized in helping companies design, assess, and remediate compliance programs and controls. And I've served on senior leadership teams for 5 compliance monitorships, all appointed by different regulators in the United States, including the Department of Justice. My current role is that I serve on the senior leadership team of a DOJ antitrust monitorship related to the merger of 2 leading wireless telecommunications companies. And that monitorship is interesting because it's not one required because of any misconduct by the companies, but from an antitrust perspective, it was really a remedy in response to the merger of 2 companies in the United States. And so our obligations are really overseeing that companies and different parties' obligations related to divestitures of assets, as well as other transitional obligations as they work with each other in order to enable a new competitor in the marketplace. Most recently, I was the chief of staff for the independent compliance monitor and auditor of Volkswagen AG related to the diesel emissions scandal. And so that was a great opportunity. As Marina said, had a very positive experience working with a diverse team with many diverse skill sets. And the monitor had a large mandate and a broad mandate to ensure that the company's overall compliance program was remediated and effective. at preventing similar misconduct in the future, but more broadly across the organization, assessing the company's commitment to compliance. And we worked with a number of very talented individuals on that team, attorneys, other accountants and consultants, industry experts, and really, made sure that we were advising the company in how to more effectively remediate their compliance program on a global basis. And so, that was fantastic. And then we also, in other experiences of mine, worked on a number of other type of misconduct related monitorships where companies had done the wrong thing and were really working hard to remediate their culture as a baseline to prevent the misconduct in the future and really transform their compliance programs. And so, given my, accounting and auditing background and as a financial statement auditor, my roots really started in that internal control space and kind of pivoted nicely into and transitioned ultimately into this world of compliance monitoring and helping companies make effective programs and controls to prevent misconduct and compliance issues.
Thanks, Michele. I feel that I have like 100 questions, and I think that we can have 2 webinars just to discuss the monitorships of the DOJ antitrust case, the wireless case, and the Volkswagen. But let me ask you something first. So in the last fall, the fall of last year, actually, the US DOJ was, I would say, quite vocal that it rescinded any guidance that suggested that monitorships are disfavor or are the exception or so on. And recently, the US Department of Justice also revisited its corporate criminal enforcement policies and clarified the factors that prosecutors should consider when evaluating whether a monitor is appropriate as part of a settlement agreement or, So in the recent US DOJ resolutions, have you noticed a theme of facts and circumstances that make it more likely that the US DOJ will impose a monitor?
Yeah, so Daniel, the DOJ has absolutely been vocal in discussing its recent enforcement priorities since the fall of 2020, as you alluded to, including the use of corporate monitors. So in the fall, Deputy Attorney General Lisa Monaco made certain remarks specifically around the use of monitors and reminded us that independent monitors have long been a tool used by the DOJ to encourage and verify compliance with government resolutions. And she made it clear that to the extent that prior Justice Department guidance suggested that monitorships were disfavored or the exception, she was officially rescinding that guidance. And on the same day, then issued initial revisions to the corporate criminal enforcement policies. Those policies reiterated prior guidance about 2 broad considerations that the department had issued that should guide prosecutors when assessing the need and the propriety of a compliance monitor. Those considerations include the potential benefits that employing a monitor may have for a corporation, but also consider the cost of a monitor and its impact on the operations of a corporation. And so the revised policy further stated that where a corporation's compliance program and controls are untested, ineffective, inadequately resourced, or not fully implemented at the time of resolution, that department attorneys should consider imposing a monitorship. So you're going to hear a theme from me on this very topic, right, which really focuses in on what companies need to do to ensure that they're remediating their compliance programs after misconduct has occurred, but also ensuring that those remedial actions are fully implemented and tested and deemed to be effective. So, this guidance was, critical in the fall of 2021. And then, as you alluded to most recently, on September 15th of this year, Deputy Attorney General Monaco delivered additional remarks on corporate crime and enforcement. And those remarks really focused on individual accountability, a company's history of misconduct, voluntary self-disclosure, as well as the topic of independent compliance monitors and a company's culture. So similarly to the fall, on the same day, there were other revisions to those corporate criminal enforcement policies. And these revisions were more robust. And really critically to the topic of compliance monitors, the policy outlines many factors that a prosecutor should consider when evaluating whether a monitor is appropriate. And so once again, in this guidance, we see that one of the themes stressed is whether at the time of resolution, the corporation has adequately tested its compliance program and its internal controls to demonstrate that they would likely prevent or detect similar misconduct in the future that brought them to that state with the department and the settlement agreement itself. And so as we kind of looked over the settlement agreements in late 2021, after the initial guidance from DAG Monaco in the fall, throughout 2022, we've definitely noticed some trends. And while each of those cases and those settlement agreements is fact and circumstance specific, and we obviously don't know all of the details and considerations that went into those settlement agreements, we definitely have seen that the Department of Justice is placing heavy scrutiny on the status and the effectiveness of a corporation's remedial efforts. And when not fully implemented or not tested and deemed effective, the imposition of a corporate monitor is likely. And of course, that's alongside a number of other factors that the department has for a long time now communicated and been transparent about. So let me just walk through some of the cases, because I think the department's comments on some of these cases is really interesting, and you'll see these trends arise. And so one of the cases related to Balfour Beatty communities, and the department had noted that there were a number of considerations that contributed to that resolution, which included the imposition of a corporate monitor. The department stated that one of the factors was that the state of Balfour Beatty communities compliance program and the progress of its remediation, including the fact that their compliance program and internal controls had not been fully implemented or tested to demonstrate that they would prevent or detect similar misconduct in the future, was definitely a factor in one of the aspects that had the department come to the resolution it did to impose a monitor. There's also the NatWest market case, where there were other considerations that the department was quite vocal about, which get back to some of the other themes in DAG Monaco's fall speech and remarks. The department stated that there were a number of relevant considerations that contributed to their criminal resolution with NatWest, including the nature and the seriousness of the offense, NatWest's substantial prior history of other criminal misconduct and civil and regulatory actions against it in the past, and its breach of a prior agreement, as well as the state of its compliance program. So here you saw that NatWest was a repeat offender, which was one of the themes of DAG Monaco's fall remarks. And so there were also compliance deficiencies. And the department also noticed that NatWest schemes were egregious, and they spanned multiple years and countries, and that the sentencing and the settlement agreement really reflected those factors as well. Then we move on to the Stericycle case in the US, where the department stated that Stericycle engaged in extensive remedial measures, or that while it engaged in extensive remedial measures, it had not yet fully implemented or tested its enhanced compliance program, necessitating the imposition of an independent compliance monitor. And then finally, we come to Glencore. DOJ stated that Glencore did not receive full credit for remediation because it did not timely and appropriately discipline certain employees involved in the misconduct, and that the compliance program enhancements were new and not yet fully implemented or tested to demonstrate that they would prevent or detect similar misconduct in the future, necessitating the imposition of an independent compliance monitor. So you see the themes that are coming out of these resolutions, right? And the topic that we'll, I think, talk a lot about today is this concept of companies that really need to hone in on, when misconduct has occurred, fixing those issues and making sure that those fixes, those remedial measures, are effective. As we turn to looking at the cases by the department in 2021, we definitely saw that the department was more comfortable with the company having a compliance program that was being remediated and they were more comfortable with imposing self-reporting requirements versus the imposition of a monitor. So you've definitely seen that theme change late in 2021 and here in 2022, where the department is definitely showing a trend of imposing a monitor. Again, fact, circumstance specific, but in particular when a company hasn't yet fully demonstrated that they've implemented and tested the effectiveness of those fixes.
Thanks, Michele. It's a great overview, and I totally hear you. But maybe let me try to get a little bit more of your experience here. So when we look at these cases, they all say, well, you don't have a compliance program that is adequate, or you haven't tested this compliance program. But in practice, what will authorities actually look at? What will they ask of information? What should companies and even outside counsels do to make sure that there is an effective compliance program that the authorities will look at and say, this is fine, this has been tested, you don't need a monitorship? What kind of specifics of the compliance program that they will look into?
Sure. So in the United States, the department is really looking at the state of the compliance program at the time of the misconduct versus the state of the compliance program at the time of resolution. And so the company and its supporting counsel and consultants really do need to examine what that compliance program looked like when the misconduct occurred and where the flaws and the gaps were, and definitely demonstrate that there's been remedial actions taken since. A good root cause analysis is critical to that, so that the company really understands what they need to fix and address, and how vast and broad across the corporation that they should look. Many corporations identify misconduct in one location or business unit, and the root cause analysis does not take into account that this could happen, or could it happen at other parts of the corporation, in other countries, and other business units. And so that root cause analysis really does drive then and create a path for the company and its counsel to really fix the problem, right, that caused the misconduct in the first place. And so particularly, kind of stepping back when before a corporation is even in discussions about resolving the issues in the misconduct, when a company is under investigation, whether it's an internal investigation or an investigation by outside government authorities, it really does need to act fast. And particularly to prepare for potential settlement discussions down the road, the company really needs to hone in on assessing the effectiveness at both of those points in time, but then demonstrating over time, because some investigations take a very long time, that they've taken remedial measures and that they've tested the effectiveness of those measures so that they can go and have proper negotiations to demonstrate their commitment to compliance, fixing the problem, but also wanting to make sure that in reality, those new policies and programs and controls, they're not just on paper. They don't just look nice and sound good, that they're working in practice. And that's really where the testing and assessing the design and testing the operating effectiveness of those compliance programs and controls is critical to really prove that. And so one is, it's got to be timely. So it's got to be done in a timely manner. But then kind of stepping back to your other question, hopefully preventing and developing an effective compliance program is the ideal state for most companies. It is an investment. But the ideal state is really starting with making sure that the company's done a thorough risk assessment, and which should drive the identification of their compliance programs and controls that mitigate those risks, as well as helps companies identify where they have gaps. So sometimes I see companies that assume that their existing compliance programs and controls are effective because they're assuming that those programs and those internal controls are effective. They don't actually test them to make sure they are effective. They assume they're working and operating effectively, which is a downfall, because down the road, they might find out after misconduct has occurred that they're indeed not effective. And so they also assume that if a company is testing its internal controls, maybe for Sarbanes-Oxley or other, based on other internal audits, that those controls are being tested as a result of those other processes across the company. And a lot of times in certain high-risk locations that may not be financially material, they skip over the fact that they've got to test the effectiveness of those controls. And so it's really, starting with that thorough risk assessment, potentially having a third party come in and periodically conduct the assessment, test the design and operating effectiveness of the controls, and then the company's internal audit function can shadow that process and hopefully create a sustainable process going forward, whereby they have an independent internal audit function who's actively and regularly testing the effectiveness of those programs. The final piece that I can't stress enough is monitoring the effectiveness of the compliance program, right? And so it's great to test it, but a lot of times companies do that once and then they assume it's working effectively. So regulators are really interested in seeing like this ongoing monitoring, this ongoing testing. And a key for companies to really think about is establishing quantifiable metrics that it can demonstrate internally to, say, its audit committees, its management boards, that they're actively monitoring the program and that they're really thinking about the effectiveness beyond just the simple testing, but with basic questions to themselves, such as, for example, a third-party management program to conduct due diligence on third-party business partners. The company may think it has a great program in place and may deem it effective through testing, but asking themselves simple questions, which I had a client that I was helping build a anti-bribery and anti-corruption compliance program who thought they had a very effective third-party management program in place, and they were reporting to the audit committee and the board how many business partners that they conducted due diligence on. And when I asked him, how many business partners has the company turned down in the past 5 years as a result of doing its due diligence on business partners, he had no idea.
0.
And he probably, that's exactly right. He probably said, well, if I have to make an assumption, it's probably 0. And so I said, do you really think that you have an effective third-party management program when you're operating in over 100 countries and you've never turned down business with a third party? Do you really think that's effective? So part of this is just common sense, right? Stepping back and really thinking through while you're doing your testing and your assessment, really, the Department of Justice guidance on effective compliance programs, if you haven't looked at it, it really does contain a lot of great information about metrics that any jurisdiction and company can apply to really monitor the effectiveness of their program. And I think that's critical.
Many thanks. That's really great. Marina, maybe let me bring you to the conversation as well to give a little bit of perspective on the Brazilian side. Do you see, maybe just to start the same question that I asked Michele, do you see any trends on the use of monitorships in Brazil? Do you see that authorities will tend to use more monitorships? How do you see this?
Let me take a step back. I was deeply envious of Michele as she was going through the precedent in the United States, because here, we're in a very different environment, right? Monitorships are not only very new, but while the US has them at this point down to a science, right? And authorities have, a string of precedent that you can cite to, and you can actually see the trends, how they evolve throughout the years, and as a result of concrete cases. Here, we're still all over the place, right? This is very much a work in progress, which is not to say that we won't get there, but there will be significant growing pains. So in terms of what are authorities looking at right now to impose a monitorship, I think we can look at the past before we talk about the present. So in the past, we were in and you remember this very well, right, Danielle and Maria Cecilia, when the conversation about monitorships started, we were in an environment in which companies really did not have a real culture of compliance. Just so as an example, and this is not privileged information, but Odebrecht essentially did not have an effective internal audit, which for a company of that size in 2022 is unthinkable, right? But back then, it really, which is not to say it was common, but it did not raise eyebrows for a very long time the way it would have today. So we were in an environment that was here in Brazil in which companies that had a compliance program mostly had it because they were subsidiaries or invested by foreign, particularly American shareholders, or for some reason had controls that existed but had never really been tested, either by third parties or, reality, or we had companies that really had almost nothing. So when the car wash operation hit, the idea of a monitorship was very appealing because a lot of those companies really hit all the requirements that Michele mentioned, and a lot of the requirements that back in 2012 were in practice by DOJ. A lot of them had to do with lack of self-reporting, lack of an internal control environment. So all of those companies, in a sense or another, really fit the profile. Not all of them had monitorships, but all of them, in a way, really fit the profile of a company that needed to be, in a sense, under the oversight of an independent individual or entity. Right now, we're at the, I would say we're at we're witnessing a different movement, right? As a result of car wash, companies in Brazil all became very keen on having a compliance structure. So this was, as you can witness, these were very busy years for compliance folks, right? Because this has become such a relevant topic that a lot of the companies just ran and put in place controls that otherwise did not exist. I think there are a few things that we can derive from what Michele just said and what we've experienced here in Brazil in the past few years. The first thing is, and Michele, correct me if you think I'm wrong, but for a monitorship program to work, it has to be tailored to the reality of the company that is being monitored. So, and I think this has a lot to do with what's the rationale behind what DOJ and precedent now in the US is moving towards, which is looking at a number of factors that have to do with industry, history of compliance, self-reporting. So thinking not all monitorships are alike, not all companies are alike, not all monitorships are alike, and the decision to impose a monitorship on a particular entity really has to be one that is tailor-made, really thought out in a very particular manner. A number of things need to come into consideration. So that is one thing that I think that, progressively, I think here in Brazil, we are becoming more aware of the fact that this is not a solution that will fit everybody. The second thing is, after this wave of compliance that started in 2015 and I would say lost a bit of its strength recently with the dismantling of investigation groups within MPF, I think what we see now is that a number of companies have created control environments that can be very burdensome, and they are looking at these control environments, or they should be looking at these control environments and thinking, what is excessive, what is efficient, and what needs to stay in place. And I think that's key, because we need to move from a position of volume, of quantity, of too many controls, to a position of quality. And I think that has a lot to do with what Michele said. Brazil does not have a culture of testing. We do have a tendency of piling on a bunch of controls and requirements that a number of people really don't know where they come from. They're just copying and pasting from what others are doing, from what is being done in the US. And a lot of these solutions really don't apply or need to be tweaked for the Brazilian reality. So this moment that we're living now, right, which is different from what we lived between 2015 and 2018, 19, 20, I think now is the moment to really do what Michele said. Look at your controls and make sure that what you have makes sense. First, because having excessive controls really means that in the long run, they will be disrespected, because if you have something that is too burdensome, that doesn't make sense, people will find ways to go around it. And this is something that we need to be very mindful of here in Brazil, because Brazilians do not have a culture of strict compliance. So having controls that are burdensome and don't make sense, of course, that when you have controls that are burdensome that make sense, it's one thing, but when they don't, people will find ways to go around them. So I think that the first movement is look at what you have and if it makes sense. And the other side of that is the only way you can make sure that it makes sense is by testing. And I don't really see here in Brazil companies with a culture of testing what they have. We do have a number of extremely well-qualified service providers that know how to do that, but this is really not something that is, at least in my personal opinion, at the top of mind of compliance professionals and companies. I think they're still more concerned about what quantity rather than what they do have. And if we ever come to another, historical moment or movement in which these controls are tested or are inquired about, I think the next chapter for us as a country will be, and for companies in this country, will be to not only show what they have, but how what they have works. And I think that will be very important in the future, because this is what, at this point, everybody has something in place. So it's not like we're not coming from zero, but the difference will be, show me how good and efficient and effective what you have is. So,
Marina, that's a well, first of all, it's a great insight, a little bit of less, maybe more, right? Focus on quality instead of quantity or volume, and avoid red tape, apply resources and put the resources in the right place where it really works. And I think it's such a great insight that before going to the next question, let me take the thoughts of Michele on that as well.
Absolutely. Marina, I agree with all your points. I think it's, even in the US,
Michele,
right?
Even just when you comment this, if you could also say how this would reflect on the number of recommendations that a monitor would give, how this will turn into quality as well, and the number of recommendations, or is it necessary to have a whole bunch of recommendations? Sorry to interrupt you.
Oh, no, that's okay. No, I fully agree with what Marina said. Even in the US, I would say when Sarbanes-Oxley first came to fruition, there were a number of companies that went to an extreme quantity of identifying what they considered to be key internal controls. And a lot of them, kind of looking back in hindsight, were not necessary. And there's a lot of, we call it decluttering of controls going on today, where companies, to your point, have really identified that it was kind of a lot of busy work, and it was requiring personnel at companies to do things that they didn't understand the value and the benefit of. So to your point, they didn't do them. They didn't follow through. Or to your point earlier as well, they found ways to override those controls to get to the activity they needed to get to do business anyway. And so I think it's an excellent point. And your comments about practical and reasonable are ones that Daniel, as I think about my experience and my colleagues' experience working on monitorships, the worst place I think a monitor can be is if they come in and don't take a risk-based approach, right, to their mandate. And Marina, you alluded to that before, that a monitorship really has to be tailored to the company, the industry, the risk level, and the misconduct that happened that got them there in the first place. And then in turn, the monitor and their team needs to do a risk-based monitorship and develop a risk-based approach and ensure that their work plan is effective and practical and reasonable, but then that their recommendations, to your point, Daniel, are also practical and reasonable. So within a lot of the Department of Justice monitorship plea agreements and settlement agreements, there absolutely is written guidance to say that the monitor can make their recommendations, and then within a certain period of time, the company, if they feel those recommendations are unreasonable or unduly burdensome, can push back. I think a more effective route is when the monitor ensures that he or she is making practical and reasonable recommendations. And part of that gets back to just basic communication, right? And so I'm sure, Marina, you can chime in here as well. A monitor can be so much more effective by having an ongoing dialogue with the company around the recommendations that they're considering making, and really socializing those recommendations with the right stakeholders at the company to ensure that it's the right fit for the company and their culture and their size and their risk level. And up front, before even issuing those recommendations to the Department of Justice or another regulator, getting the company's buy-in. I mean, I think that's critical, and then making sure that along the way, as the company is making those changes, that recommendation still makes sense. I mean, a company, a global corporation of a certain scale and size, their risk landscape changes very frequently and quickly. And so there are things that when a monitor issues their recommendation today, maybe 3 months down the road may not fit the company and its risk landscape and its operations. and it might not make sense. So that ongoing dialogue throughout the monitorship, I think, is so critical. Marina, I don't know if you agree with that or what your experience has been.
I don't think I can agree more. And ultimately, the success of a monitorship, it comes down to a lot of things. But if I were to mention one, I think it's dialogue. This is from the start, right? So this panel talks about, how to make monitorship successful for clients. And I think the first step is, the choice of the monitor, right? That it has to be a good fit. And from the beginning, I think the company, assuming that at some point it will have to internalize that this is being imposed to them after that initial stage, I think it really comes down to, being able to present adequately to the monitor. How does that company function? What is the culture? How things have been done from the beginning. And from the monitor side, I think it's a posture of knowing that the monitor does not have the power to change the entire culture of the company, but it can help the company put in place controls that will help it elevate the way it does business and conducts itself, before society and as such. So it really is the most successful monitorships that I know of are a dialogue. And you said you mentioned a few very practical things, which is sharing the recommendations, sharing impressions, frequently being in touch with the company about how the monitor feels that the process is going. The company's keeping, its developments organized and being able to show it to the monitor. It doesn't mean that the monitor needs to accept everything that the company says. No one would, in this group, would think that, right? The monitor has the final say, but this can be a well-informed process that will be much less traumatic for the company, for the monitor, and much more successful and much more likely to ensure that change will be permanent, right? Because that's the whole point, is ensuring that this is not something that is going to be in place while the monitor is there, but that will outlive the monitor. The monitor's main purpose is being able to leave, right? I think that's the goal. It's just, it's like a parent in a sense. It's your success is measured by how independently that entity will survive. So, and that can only be accomplished through dialogue.
I think that's great. And I would also say, just because the phrase, independent monitor or independent compliance monitor has independent in it, doesn't equate to adversarial, right? So the relationship that the monitor and their team develop with the company and vice versa, and with the regulator, it's really a triangle, right? And there's got to be effective communication across that triangle. And there really is a shared goal amongst all those parties to your point, create a sustainable compliance program to prevent or detect misconduct in the future. And so really, I think focusing on that shared goal and setting the right tone at the top from the beginning which starts with effective communication, and it starts with each party really appreciating where the others, stand, kind of putting yourselves in their shoes, right? Thinking about the employees at a corporation that see a monitor coming in that can be intimidating, and employees have just been through a probably very challenging time with the investigation, and they're tired, they're exhausted, and so when the monitor comes in,
they're afraid, they're tired, they're afraid.
Yeah. So it's a very delicate situation, and making sure the monitor and the monitor's team does not approach this like an investigation. That you're meeting with employees, you are not interviewing witnesses, right? those things may be subtle, but they make a big difference in the tone of the monitor team and the relationship.
And Michele, that's great. I like the independent does not mean adversarial. This is a very good takeaway from this. But let me ask you one question then. What to do when it becomes adversarial? What to do when, things start not working well, or the monitor thinks in one way and the company thinks in another way? How to arbitrate that in practice in the best way possible?
Yeah, I mean, I'll start, and Marina definitely chime in. I think part of it is trying your hardest and your best to not create an adversarial environment in the first place, and anticipating that things could get challenging throughout that period of the monitorship. That's typically, at least in the United States, the time period is 3 years. So you're in for the long haul, and so from the beginning, I'm going to get back to some themes. Communication. That's throughout the entire process. So it's establishing that up front, whether it's working with the monitor and talking to the monitor actively around their work plan, around reviewing and socializing the recommendations. Certain monitorships require the monitor to certify to the effectiveness of the compliance program at the end. So understanding the company having an active dialogue to understand what the monitor's certification criteria are, so that they know well ahead of time how they're going to be judged and assessed. Working together with the monitor to prepare for meetings with the regulator, having solid communication and ownership and responsibility throughout the company to really drive and implement the monitor's recommendations. I've seen very effectively done by some companies where they've had board level ownership of recommendations to ensure that they get implemented timely and effectively. And so if you're having that ongoing dialogue from the beginning and throughout the different phases, hopefully the things that are causing friction can be actively discussed. You're not waiting to tell the monitor about issues that are happening. You're doing that proactively. If there's other misconduct that's being investigated, letting the monitor know about what the company is doing and how they're addressing it. These to me all lead to hopefully a lack of this adversarial butting of heads, but inevitably that does happen. And so it's just making sure that I think the right opportunity exists to have that open communication, like in any relationship. So when the company disagrees with the monitor, it's really helping the monitor understand the basis for that disagreement. What are the facts and circumstances on the table that make that recommendation unduly burdensome, and talking to the monitor and their team like they're humans, right? They understand, they appreciate that the company did not want a monitor. They did not want somebody coming in and interrupting potentially and disrupting their day-to-day operations. And so really on both sides, appreciating the viewpoint from where the company is coming from or where the monitor is coming from, and really helping get that dialogue on the table to understand like what is a more practical and reasonable path forward is key. And then to the extent there's still a disagreement, that's where a lot of the regulators have in their agreements, there is a remedy for a company to go to the regulator and have an active dialogue with the regulator as well around what the issue is and what the challenge is. But I would absolutely recommend that the company try to work with the monitor and the monitor team first. And if they can't come to some resolution, and then let the monitor know that the next step is going to talk to the regulator, and is there anything else that they can do to have an engaging discussion between the two parties before that happens? I think you're going to find that if you get to that point where the company is going to the regulator, then that creates that's a tough landscape to maneuver through. And so doing as much as possible upfront from a planning perspective to create these effective communication mechanisms throughout from the beginning and in those critical time points, I think is so key.
Marina, any thoughts on that?
Completely agree with Michele. And I think that it needs to be acknowledged that, as she said, a process like this does not become adversarial overnight, right? Unless you are dealing with parties that are completely unreasonable, this is not a relationship that sours from, in 24 hours. This is something that is that usually starts to deteriorate, and the signs are very clear. Again, as Michele said, I think it's extremely important to have checkpoints, regular checkpoints between company and monitor, and they need to be formalized. So, regular meetings, establishing when documents, when draft recommendations, draft reports will be shared and will be discussed. Again, does not mean that the monitor has to take every suggestion from the company, but at a minimum, the company needs to not be surprised. No surprises, right? Even if the monitor is unhappy, this is something that needs to be known well in advance. If I were to add something to what Michele said, and I think this is really important also with regards to the education of regulators and authorities, because this takeaway that a monitorship is an independent but not an adversarial process needs to be understood by companies and monitors, but it also needs to be understood by authorities. So authorities need to be able to look at this if it comes to that, if either the monitor or the company come with a problem, right, that has to do with lack of communication, a relationship that has deteriorated. The authorities also need to be able to look at this independently and be able to make a determination that is reasonable and that is just, right? This is a very loaded word, but usually companies that are in a situation that of having received imposition of a monitorship usually have a relationship with authorities that is already deteriorated. Authorities don't trust that company. The monitorship was imposed as a result of this lack of trust. But authorities also need to be able to, at some point, turn the page and assess what's being presented to them in as unbiased way as possible, because otherwise it also becomes impossible for the company to put forward requirements that may be legitimate, that may make total sense. So I think that's something that needs to be, I think, well understood by authorities as well. And the other thing that I was going to say is sometimes, well, as in any relationship, right, Michele, sometimes communication is broken down. And it's really hard because both parties lose the ability to actively listen what the other is saying. And when it happens, it's very difficult to move forward, right? So sometimes it may make sense to bring in someone else, right? Someone else that can work as sort of a mediator or look at what's happening and, give an opinion as to how things are going, how the company can better comply with what the monitor is saying, make the company see why the monitor is acting in such a manner. So that's also, that may be a step before engaging the authorities and bringing the conflict to the authorities, notwithstanding what I said, that if engaged, the authorities should be able to look at conflict in an unbiased way.
Thanks, Marina. Maybe just not to be the only one asking questions here, we have a question from Renata on our Q&A. I think this is addressed to Michele, and it was actually, the question relates a little bit about your previous answer on testing of the compliance program and how we can do that. So she asked whether it's fair to believe that education is also a part of this strategy, showing to the authorities, that we have courses, mock-up situations, and so on. So Michele, maybe you can answer directly to Renata here.
Yeah, no, I think I'm looking at the questions, some of them are around, what's the most important evidence that can be shown to demonstrate the compliance program is fully implemented. And yes, is education a part of the strategy? So I think part of, if I were working for a corporation and I wanted to ensure that the compliance program was effective and that there's evidence that it is, the remedial measures have been fully implemented and tested, you've got to show that evidence, right? You've got to not just have what I would call an inquiry-based assessment done. Testing is more about gaining evidence, and evidence can be gained, with my auditor background, right? Evidence is gained in a number of different ways, and it's not just based on inquiries. Inquiries is a start in the beginning, but actually making sure that when your program is being tested and your remedial efforts are being tested, that you are doing walkthroughs of the new processes that have been designed and implemented, that you're taking a transaction and following it through the process that has been designed. You may find right away that it's not effective and it's not working and it's not practical and reasonable. But then when you do have those programs and controls in place, it's kind of classic auditing evidence gathering, which is if you're testing a control, you've got to pick a sample. You've got to pick a risk-based judgment sample that hones in on gaining evidence that what the company says is in place is indeed in place, whether that's the code of conduct and employees certifying to the effectiveness or they're certifying that they're in compliance with the code, or whether it's the third-party management due diligence process that gets employed. Going through and selecting a sample and gaining that evidence and documenting the results and the conclusions based on what the outcome of that testing is, and making sure that there's a clearly documented path. A lot of companies' internal audit functions that they now have today have a very clear process in place to develop their work plan, document their testing and their conclusions. But then it's really making sure that where there have been issues identified, that those issues then are tracked from a remediation standpoint, that the accountable party within the business or within internal audit or finance or legal, whoever it is across what I call the 3 lines of defense, right? You have the business owners, you have legal, you have finance, you have compliance, and then you might have internal audit. So it's making sure that all of those lines of defense are actively working to test and document and verify that these takeaways are being acted upon. So when there are issues identified, let's say 5 of the 20 transactions or controls that you tested did not work, it's scrutinizing those and saying, is this all in one location or one business unit? Again, what's that root cause of why this isn't working? And then what's the remedial action and tracking that and making sure that it's timely addressed? And again, documenting those efforts and documenting the monitoring over and the oversight over the remedial actions taken. The worst position a company can be in is to test its program, find deficiencies, have great recommendations to remediate those flaws, and then never follow up on those and never show that ongoing monitoring that should be taking place. And part of it does get back to education. It's educating employees around why you're testing the program. It's educating your employees around how important it is to demonstrate that the remedial actions are taken and what that looks like from a documentation standpoint and in practice. So I think it's also about, when I think back to like the establishment of these metrics for which companies want to demonstrate ongoing evidence that they're enhancing their program over time, you should document that. So if you're doing an annual assessment, if you're doing annual testing, it's stepping back and demonstrating where you've made those remedial efforts and how you've enhanced the program, what you did, and the risk-based approach that the company took to making those remedial efforts. And again, it's risk-based. So not boiling the ocean, it's really focusing in on your resources, dedicating to those high-risk areas and showing that linkage, I think, whether it's in a risk assessment or otherwise, is critical.
Thanks, Michele. I think that you make the work of the moderator really, really easy here. Maybe, well, today, of course, as we go towards the end of our webinar, we discuss a little bit how to avoid monitorships, having an effective compliance program that remediates the root cause, that is sufficiently widespread, effective, and tested. I think that Michele and Marina put a lot of emphasis on testing, focus on what's really happening. But also when you develop a compliance program, to focus on quality instead of volume, instead of quantity. We discussed a little bit how the monitorships should work with the company, having a risk-based approach, practical and reasonable recommendations, knowing its role as independent but not adversarial. And when the communication is broken, use the methodologies that we have available, including potentially using the mediator, instead of even turning to the authority. Of course, the authority will be there if necessary. And I think that one important takeaway for us is that in order to achieve success in a monitorship, dialogue is of utmost importance. It's extremely relevant to have this dialogue with the companies, and success may be measured by being able to leave the company, leaving the company on its own. So, thank you very, very much for your thoughts and, the participation in this webinar. I learned a lot. I'm sure that everyone, our audience, also learned a lot today. Maybe just to finish, final words on this, and what should monitor that has been appointed should really, look at and should really focus when starting a monitorship. We can start with Marina.
Hi, Danielle. Well, as my closing remarks, I would like to say this was such a pleasure. And I think that Michele talked a little bit about education and what you guys are doing, bringing someone as experienced as Michele to talk to a Brazilian audience about monitorships is really part of that effort, because this is something that needs to be built in a sense that, authorities, the public, council, service providers, this is something that needs to be well thought out. And this is, I'm very happy to be part of this panel today, because I believe strongly in this aspect of education. So thank you again for the invitation. And your question was, what should the monitor be looking at, right, when it enters a company, right? Well, I think there are a number of things. I think the monitor also needs to be very self-aware as to whether he or she want to take on that particular project, and be very mindful of the real challenges of a particular entity. But I would say that one of the things that a monitor should do as they enter a company is identify who are the people that he or she can trust, right? Who are the point people? Who are the real point people? The people that are going to tell them what it is, not necessarily what the monitor wants to hear, not necessarily gossip, which happens quite a lot as well, because the monitor often becomes that person, Michele knows very well, where all the complaints kind of, end up at. But really, who are the people that he or she can trust, that, have the best interests of the company in mind, and keep those people close, right? And earn their trust and their respect. And the opposite is also true. And I think that's a very good first step to dialogue and, mutual recognition and respect.
Thanks, Marina. That's one additional great insight, finding the right people. Michele, do you want to give us your closing remarks?
Sure. So I think what Marina said is critical, and there's almost like these mini partnerships that should get created across the organization and the monitor team, right? So oftentimes, depending on the complexity and the global nature of the company and the monitor team, there's got to be relationships developed kind of across the team, right? And so Marina very much alluded to these strategic relationships, right, with senior management and others that have the influence at the company that can really help guide the company to do the right thing and make the changes and get the support of employees to do that. But I think it's also key to have those relationships kind of cascading down throughout the monitor team. Having these partnerships, or, from a project management standpoint, these liaisons across the different work streams and areas of focus that the different members of the monitor team are engaging with different folks at the company across different functions and business units and geographies. All of those relationships matter, right? Because you have the day-to-day communication and where all the work is being done, and the people that are responsible for rolling up their sleeves and implementing those recommendations, all the way up through the board, senior management, audit committees, management boards, supervisory boards, et cetera. And so it really is kind of thinking about who to pair up with whom across the monitor team and across the company, and making sure there's no gaps there. So I think that was a fantastic point. I think what's also key is, for the monitor and the company to have an upfront discussion around, what the monitor is not going to get involved with, right? So again, Marina's great point that the monitor oftentimes becomes a mechanism for anybody to voice a complaint or an allegation or a grievance. And the company should already have a process in place, hopefully through a whistleblower hotline and other mechanisms where a lot of that information, those allegations and grievances are funneling through. And so the monitor needs to have an agreement with the company of what the process it's going to take when it does receive those types of grievances, and respect that the company already has certain processes in place to maneuver through those challenges and not feel that they have to get involved in every one of those. You know, the monitor needs to appreciate their mandate and that there's business decisions that they're not responsible for making. That's the company, right? And so it's just, I think, you know, equally critical knowing when to get involved, but one, knowing not to get involved, you know, and being sensitive to that throughout the engagement.
Thanks a lot, Michele. Well, and thank you both. As I said, it was a very interesting webinar. I thank you for being here, for your time, and also I'm sure that our audience appreciates everything that you told us today. So thanks a lot. I think we come to the end of our webinar. Wish you all a lot of work, a lot of nice monitorships, and hopefully we will collaborate in some of these projects. Thank you all. Maria Cecilia, do you want to say something?
Yes. First, I would like to say that as Marina, I also believe in education. So this is one of the reasons that we are here today. But Danielle already made a summary of all the things that we discussed. I would like to thank to Michele and Marina to share their experience, their thoughts. I received some messages in my mobile that I'm going to answer later, say it was a very, very richful discussion. So I would like to say thank you again.
It was a pleasure working with all of you, and thank you for having me and inviting me. And it's just been an amazing discussion, Marina. I hope that we keep in touch, and Daniel and Cecilia. We're really looking forward to staying in touch. And thank you for everybody who joined the webinar today.
It was a pleasure.
Thank you.
Goodbye. Have a great week.
Bye-bye.
Bye.
Bye.